Court calls the case, People versus Jerome Burns. Well, he's in back, right? So we might have to wait. Oh, no, there he is.
And this is the public information not to carry out the ruling matter on behalf of the individual most heard. Mr. Burns, say your name for the record, please.
Jerome Robert Burns.
The people's motion, this was discussed this morning regarding access to the premises.
Yes, Your Honor, I did send that motion to since then, counsel and I have been speaking. It's my understanding that the apartment is actually leased to defendant's father and I believe his mother potentially. I don't believe the victim is on that lease, even though that was her home and that was her residence. So I wanted to forward that information to the court. I don't believe that we are in a position where we can ask, for her to be able to stay in that residence since she's not on the lease and it is the defendant's father who is.
Well, I think we're absolutely in that position. I mean, that would occur, that occurs all the time. Well, and the problem that I have with not being able to do it, or at least forcing it to happen, is that you would have individuals that may be potentially victims of, in a domestic violence situation, where the leased premises, which is their home, is leased to somebody else, and then they can't go back there, and they didn't do anything to be sort of on the outs.
Judge, if I may, I think there's a little bit more information that the court should have.
Okay.
My understanding, my client's father is here present. He was the one that was able to update us on what was happening. The apartment is leased to him and his wife. That has been their home for the past 9 years.
Whose home?
Father and mother, not defendant and complaining witness.
Okay.
Yes, so it's leased to them, but that's their home. And my client and his wife were living with them at the time. They still...
All right, guys, this courtroom drama kicks off fast. Jerome Burns stands accused, but the real focus? A home that's not even in the victim's name. The defense says the apartment belongs to the defendant's parents, so she can't stay there. But, hold on, she lived there too. The judge isn't buying the eviction excuses.
Live in the home currently.
Okay.
And my understanding as well, and it states it in the report, before this incident even occurred, the complaining witness had left the home. She had already moved out of the home. I know that the original allegation or issue was that there was the locks in the home were changed.
Yes, that's what I heard.
That is correct.
Why I set the hearing.
I spoke with Dad about that, and Dad said, yes, I did change the locks because she had since moved out the home probably about a month before then. And later he found out that the complaining witness was entering the home with the keys that she did have while he wasn't home, moving things around. And he stated that he felt it was necessary to change the locks because she was no longer living there.
Your Honor, my understanding is that the victim left because of the physical abuse and fear by the defendant. So she left and sought a safe place for her and the child. So that part's true. My understanding is the same, that she left, however, under those conditions, and I think that is an important addition. But going back to why I don't believe we cannot exclude defendant's father from a place where he's leasing, of course. So in regards to that matter, we'll just ask for there to be a civil standby so she still has belongings there. I of course ask that none of her belongings be touched by the defendant's family and that they cooperate with law enforcement to allow her to come and retrieve those. There's also a matter of the vehicle. So at this point, the concern I have for this victim, and more so for the child, quite frank, is that this child has very serious medical needs. This sexual assault took place at Mott's Children's Hospital. While their child was in the hospital, the defendant sexually assaulted the victim.
Let me tell you something wild. Turns out, the locks were changed behind her back. The dad admits doing it after the victim moved out, but prosecutors reveal she left because of fear and abuse. This isn't just about a lease. It's about safety, trauma, and the messy truth hiding behind paperwork and landlord games.
This victim is in fear of the defendant. She, as far as I know, does not have a home to go to. She, as far as I know, does not have a vehicle for transportation. And we're not just talking about going to get groceries. She has a child who has serious medical needs. And so it's concerning to me that she is not able to take that child where that child needs to go for medical needs and other basic necessities. So she's, of course, in a very, very bad situation. The two of them are married. There is a car that is, from what I understand, just sitting there, and there are car keys that go to that car. Counsel and I have been speaking throughout the day, and I thought we had an agreement that the victim could use the car, since it's just sitting there, and she desperately needs it for they have in common, to be able to do what she needs to do for that child. Since then, I learned that the defendant is not agreeing to that. My understanding is that he has some concerns about the condition of the car. And I'll let Ms. Akuri speak to that. But again, my more immediate concern is this child right now. I'm not suggesting we should talk about the ownership of the car, but I don't understand why this victim cannot have access to their joint car to transport the child if she needs to.
And Your Honor, I did have an opportunity to speak with my client. Initially, the client's father, again, was the one who was able to facilitate. He did inform me where the vehicle is, that there are keys to the vehicle. And speaking, he doesn't have permission to give them over, obviously. I spoke with my client. He reports that there is front end, it's not damage, but there are front end issues with the vehicle. It's a work truck. It's a very...
Voice hears where it gets worse. She has no home, no ride, and a child with serious health problems. While her kid was in the hospital, she was assaulted by the defendant, and now she can't even use their shared vehicle. The judge hears the pain in this situation and starts asking real questions about priorities.
Large truck. It's a Chevy equivalent to, I think, a Ford 350. It doesn't have any of the additional enhancements, but he said it's a very large truck. All of his work stuff is in there. He's concerned.
His work, dad's or
my client, Your Honor. This is his vehicle. He reports that this vehicle was his prior to. He does not feel that it's
prior
safe
to
marriage. I apologize, because the people indicated that this is like joint marital property or something to that effect. But this is a work van or truck that he has been using for his construction business. I do not think when she left the home, she left without the truck, Judge. The truck has only become an issue now. And I don't really understand how, if there is an emergency, the truck would really be of any help, because I think 911 would be the more plausible way to go if there's a medical emergency with the sick child. Back to the truck though, Judge. The truck, we don't know.
I guess I don't get this. I mean, I'll let you finish.
Sure.
But these are two people, married and or not married, who have a child together
Correct.
that has special needs and may require medical care.
Mm-hmm.
For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
That's not necessarily what we're saying, Judge. I think that my client, again, with the mechanical issues with the vehicle, he indicated that it's not safe for her to drive. So it's not the safest vehicle to turn to if you needed anything in regards to transportation. And also, if he was in a...
The truck argument explodes. The defense calls it a work truck, says it's unsafe, too big, full of tools, and not her business. But let's be real, when a sick child needs to get to appointments, should a van sit unused? The courtroom heat rises as both sides argue about ownership, safety, and control.
The process of getting the condition or the issue of the car fixed, and he hasn't been able to do that. So it's possible that driving it any further would possibly make it, put the car in a worse condition mechanically. What else to do?
So, Your Honor, if I may.
Yeah.
I'm not here to argue the condition of the car. I understand this is all coming to the defendant. Again, and I want to be very clear that the victim has not asked for access to the car. I reviewed the case. I found that she does not have any transportation. And based on my experience, that is concerning to me when there is a sick child. How that car may be affected, potentially or not, by her driving it to provide for this sick child doesn't really matter. That is not what matters here today. This is an urgent situation. It's bad enough that she is homeless because of the physical assault she endured while having a sick child, dependent child. The least we can do is give her access to the car for those purposes, and then they can work it out later. I'm not worried about whatever's going on between the two of them. She needs to be able to have some transportation. She has a small child that is sick, and she needs some help.
And Your Honor, my client, he did raise his hand. He just wants the court to understand that he's not trying to keep the vehicle from them. He says it's not a safe car to drive at all. That normally when the child has appointments, the state provides transportation for the child to get to and from his appointments. He has indicated to me that he has transported the child in their vehicle previously, but the wife does not normally drive that vehicle. It's not a vehicle that she's used to driving. She doesn't drive it normally. It's his work truck. And aside from...
So she's incapable of handling what would be...
No, I don't know.
$350?
I don't know if she's licensed. I don't know if she's insured on that vehicle. I don't know. She's not. They're just...
Not insured?
She's not insured on the vehicle, Judge, according to what my client just told me.
How does that happen?
It's a joint insurance. So if I would have added her to the insurance, then she'd be able to legally drive that vehicle. If she's not added to the insurance, she legally cannot drive that vehicle.
That's not what he's asking you. Why did he
Your wife?
Do it.
why did he
Really?
insure her in the vehicle?
And it cost way too much money having her insured on that vehicle.
And that's my understanding, Your Honor.
Was there a vehicle she was insured on?
When her dad,
Get serious. This woman is homeless, without transportation, caring for a sick child, and now two men are deciding if she's allowed to drive. This is domestic control in action. The judge shuts it down, saying she's grown and can choose for herself. Access to that vehicle isn't a privilege, it's a necessity for survival.
had a vehicle for her, she was insured on that, and had received a...
Where's that vehicle then?
That was 7 years ago, sir.
And that's...
So for 7 years, she hasn't been able to drive?
She's able to drive, she just hasn't, she chose not to.
And that's kind of what Dad told me, Your Honor. Dad just says he doesn't really know her to drive. She's not one that drives normally. She's usually at the house, or they use the transportation provided by the state whenever they needed to take the child to the vehicle. Other than that, my client was the one who would do the majority of the driving.
Your Honor, what we're seeing, I'm sorry, this is a perfect example of the worst domestic violence dynamic you can possibly imagine. The fact that the defendant and the defendant's father are deciding whether or not this victim can drive a vehicle, when she can drive, how can she, I mean, this is...
I don't think that that's what we're saying, Judge. We're just stating facts that he stated that she had a vehicle at one point. She no longer has a vehicle. If she doesn't have a job to go to and she doesn't have any other need to drive, all we're stating is that she does not drive normally. The bottom line on our position, Your Honor, is my client indicates that the vehicle is not safe. Now, we've concluded from him that she's not insured on the vehicle. I don't know the status of her driver's license. So honestly, I think that this is a family law issue. I don't think that this pertains to our case at all. She left the home previously, before this case happened.
I want the keys turned over.
You want the keys? No worries, Your Honor.
I want her given access to the truck. She can then make, I'm assuming she's a grown woman, so she can make her own decision as to whether or not she wishes to drive that truck.
Okay.
She can also make her own inquiries as to the insurance that's available on that truck and the like. She can even take it to a mechanic and have them look at it as to its roadworthiness. But she's grown and she can make her own decisions and doesn't have to have defendant dad make those decisions for her.
So how are we gonna get these keys to her?
Dad says he has the keys. It's not with him right now, but I mean, previously, again,
Them to the public defender's office can get them to the prosecutor's office can get them to the victim.
All right. What do we then need to do on this case?
so Your Honor, initially we were asking for the adjournment. There was a little bit more discovery or investigation, I would say, on our end that we needed to complete before we decided which way to go.
Want the 5th or the 12th? Counsel?
I didn't hear you, Your Honor.
5th or the 12th?
Let's do the
I mean, he's in custody, that's why I'm asking.
let's do the 5th, Judge. That's fine.
June 5th, 2025. 9 a.m. or as your invite indicate. Bond will continue.
Thank you, Judge.
And I have
In the final moments, the judge demands solutions. Get the keys to her, he orders. No more debate. Whether through the public defender or prosecutor, those keys are getting delivered. A new court date is set June 5th. Bond remains. One thing's clear, this courtroom won't tolerate leaving a victim stranded while a child suffers.